Ajmair book Civil Passage number 21 recorded by B&A Shorthand Studio. Dictation speed 100 words per minute. Ready, start. Briefly, the facts are that pursuant to advertisement published in Daily Nawai Waqt, Multan, in its issue dated 3rd November 2008 invited applications for appointments against posts of various categories in MAPCO, and ultimately appointments were made by the authorities. Some of the persons who were not recruited filed various writ petitions before this court at Bahawalpur bench and vide a detailed judgment dated 17th June 2010 passed in writ petition number 701 of 2010 Safdar Hussain etc. versus Water and Power Development Authority etc. The whole recruitment process was scrapped. It is pursuant to the said judgment that through impugned officer orders, the services of the petitioners were terminated. Hence, these writ petitions, para, precisely the arguments on behalf of learned counsels for the petitioners that at the time when basic judgment dated 17th June 2010 was passed in writ petition number 701 of 2010 etc., the petitioners were not made party to those proceedings or they were not afforded opportunity of hearing, thus, they were condemned unheard, further, argument on behalf of the petitioners is that even when the impugned office orders were issued, whereby, their services were terminated, no show cause notice was served upon them, therefore, the impugned office orders being violative of fundamentally noun principle ordi alterum patrum cannot sustain in the eyes of law. It may be mentioned here that a writ petition number 8444 of 2013 Sayyid Mujahid Abbas versus Deputy Manager etc. arising exactly out of same facts, remained pending before another bench and was transmitted to this court later on. Therefore, Malik Muhammad Naeem Iqbal, advocate for the writ petitioner, was heard on 19th December 2013. Para. On the other hand, the learned standing counsel, the learned legal advisor for MAPCO assisted by their representative and the learned counsels representing private respondents have opposed these writ petitions by arguing that the main judgment passed by this court at Bahawalpur bench has attained finality and it was pursuant to the said verdict that petitioners have been removed from service. It is further pointed out that after the said judgment, after scrapping whole of the recruitment process, a fresh process was initiated, wherein, the petitioners participated. They were given extra marks for experience, but they failed to complete on merit, therefore, they are now stopped by their conduct to file the instant writ petitions. I have heard the arguments of learned counsel for the parties at considerable length and examined the record with their assistance. At the very beginning, it may be made clear that the judgment dated 17th June 2010 passed by this court in writ petition number 701 of 2010 Safdar Hussain etc. versus Water and Power Development Authority etc. is not open to question before this court in these proceedings, nor the findings recorded or conclusions drawn in the said judgment, could be questioned through writ petition. If any of the party, was aggrieved of the said judgment on any aspect, comma, the law provided entirely different mode of proceedings for the aggrieved person, full stop, in this view of the matter, comma, until and unless, comma, the competent court of jurisdiction records anything to the contrary, comma, the said judgment shall be considered final along with its conclusions. Full stop, stop writing please.